Hello, everyone, and welcome to Uncivil Law. I hope you are well, and we are here with a major issue of Second Amendment law today from the U.S. Supreme Court. They have issued their ruling in the case New York State's Pistol and Rifle Association, and as we expected, it is mooted. They have said that the underlying case is no longer pending. The issue has been resolved because New York City went to New York State and got the issue resolved, so the Supreme Court wouldn't have to decide it. And that was what I predicted. I said 98% chance that was going to happen. The only question was with or without commentary. I did not know. And it turns out with commentary. We have quite a lot of commentary, in fact, 32 pages worth of commentary. And we're going to read it and try to tease out the tea leaves of what we think is happening. Because, we don't have a lot of actual case law to read. Since Heller and McDonald, there hasn't been much that's happened in Second Amendment law. There was that one case, I think it was out of Massachusetts, dealing with stun guns, was kind of under the radar. But other than that, not much from the Supreme Court. So we have to read tea leaves. So let's do that. We are in the United States Supreme Court case of New York State Pistol Rifle Association versus the City of New York. This is per curm, which just means that it's issued in the name of the court as a whole. Some people think it means unanimous. It does not. It just means it's issued without an author. And there's no particular rules about when it's issued in the name of an author or not. As far as I know, they just kind of decide for no particular reason. All right, let's see what we got. In the district court, petitioners challenged a New York City rule regarding the transportation of firearms. Petitioners claimed the rule violated the Second Amendment. The rules were pretty tight. They forbid a person from taking a firearm from one home to another, forbid a person with a premise license, which is, for a business, from taking it out of the premise to go to shooting ranges, forbid people from taking shooting ranges out of the city, and there are a whole bunch of other restrictions too. So there are a whole bunch of restrictions dealing with transportation of firearms. The petitioner sought declaratory and injunctive relief against the enforcement of the rule insofar as the rule prevented their transportation of firearms to a second home or to a shooting range outside the city. So yeah, it was a very broad law. They're seeking very narrow relief because, as I've been telling people when we've been discussing the Second Amendment issues, the way to do this, at least in my opinion, and the way that the lawyers who drafted this seem to be trying to do this, is to do this one piece at a time. We want to do this very slowly. We don't want to overreach and get blowback. We want cases that are so clear they can only go one way and establish a nice foundation before we reach for more. So they were asking for a very minimal relief. We're looking for a right to bear case of some description, of any variety, so that we can have a foundation to build from, right? So that's all they were asking for. Very narrow relief to a very broad law. We grant certiorari. Then, after we grant certiorari, the state of New York amended its firearms licensing statute, which was hilarious. And the city amended its rule. I think it was the other way around, but I'm not sure. I think it was the other way around. The city amended its rule first, and then the state did it, but whatever. So the petitioners may now transport the firearms to a second home or shooting range outside the city, which is precisely the relief the petitioners requested for in their prayer of relief. So yeah, this is a downside, but up until the moment the Supreme Court grants cert, New York City was saying, we love our law. We think our law is great. You shouldn't be allowed to do any of these things. No. And then the minute the Supreme Court said, we'll take the case, we said, how'd you like to have everything you ever wanted for? It's a very strange thing. Thank you, Big C Burger, for the membership. Thank you, $2 from the Surly Sasquatch. New York and Gungs reflexes New York and Gungs reflex facepalm. Yeah, I couldn't agree more. That's why I don't live in New York. Petitioners' claim for declaratory and injunctive relief with respect to the city's old rule is therefore moot. Petitioners now argue, however, the new rule may still infringe their rights. So they argued a specific law with specific things, and they say, well, there might still be an issue. In particular, the petitioners claim that they may not be allowed to stop for coffee, gas, food, or restroom breaks on their way to second homes or shooting range outside the city. I believe the exact phrase used in the current rules is continuous and uninterrupted travel. And there's an issue of what exactly does that mean? In oral arguments, the New York government argued before the Supreme Court that you could stop for gas, food, and restroom breaks. So they said that even that was not an issue. The city responds those routine stops are entirely permissible under the new rule, which is what we heard in oral argument. We do not here decide the dispute about the new rule. As we stated in Louisiana versus Continental Bank, our ordinary practice in disposing of a case has become moot on appeal is to vacate the judgment with direction to dismiss. Okay. However, an instance where mootness is attributable to a change in the legal framework governing the case, and where the plaintiff may have some residual claim under the new framework that was understandably not asserted previously, our practice is to vacate the judgment and remand for further proceedings in which the parties may, if necessary, amend their pleadings or develop the record more fully. So if the legal framework has changed, we'll give you another go. The petitioners also argue that even though they have not previously asked for damages with respect to the old rule, they still could do so in this lawsuit. Petitioners did not seek damages in their complaint. Indeed, the possibility of damage claim was not raised well into litigation in this court. No particular opinion as to whether or not you should have asked for damages or not. It does cloud the issues, and the injunctive relief was a reasonable thing to ask for. The city argues it's too late for the petitioners now ask a claim for damages. I'll remand the Court of Appeals and the District Court may consider whether petitioners may still add a claim for damages in the lawsuit with respect to the old rule. I mean, at this point, a little who cares? Because even if you get the damages for the old rule, it's not going to solve the problem you're trying to solve. The judgment for the Court of Appeals is vacated, and the case is remanded for such proceedings as is appropriate. It is so ordered. Thus ends the decision of the Supreme Court. Slightly longer than I would have expected, but it is what it is. All right, so now we're going to read tea leaves. This is the exercise where you came for. We're going to read this, try to figure out what they're saying, and try to figure out, what the justice's postures is with respect to any cases going forward. So that's what we're going to try to do as best we can. So we start with Justice Kavanaugh. I agree with the per curiam opinion's resolution of the procedural issues before us, namely, the petitioner's claim for the injunctive relief against New York City's old rule is moot, and petitioner's new claims should be addressed as appropriate in the first instance by the court below. Fair enough. I also agree with Justice Alito's general analysis of Heller and McDonald, and I share Justice Alito's concern that some federal and state courts may not be properly applying it. Well, that's one very, soft way to put it. The courts of appeals have mostly been ignoring it, so that's been a problem. The court should address that issue soon, perhaps in one of the several Second Amendment cases with petitions for certiorari now pending. So it sounds like Kavanaugh is a vote to hear one of these other cases that are pending. And personally, I think they should grant cert in a couple of them, so hopefully one of them will survive to an actual decision, given the way things are going. But Kavanaugh sounds like he's a vote to do this. He thinks it's moot, but we should grant something else. There's a lot of cases that are ready to go. The Supreme Court does get, trying to remember the exact number, but they get a lot of petitions, and they only hear 0.7, 0.8% of them in any given year. So, there's plenty of them ready to go right now they could hear from. So, dust one of the other ones off the pile, and let's do that. Yeah. Justice Alito, with whom Justice Gorsuch joins, and with whom Justice Thomas joins, except for Part 4B, dissenting. Okay, so we got a couple people, and I assume this is where all the bulk of it is coming from, from these three people dissenting. All right. By incorrectly dismissing this case as moot. So we got three justices who say this case was not moot actually. Okay, so that'll be interesting to see whether or not I agree with them or not. Because I didn't look into it with the greatest level of depth. So, I don't have the deepest understanding, but my understanding was that it was moot. So if they want to convince me it wasn't moot, I'm certainly up for that. So let's see if they can convince me. By incorrectly dismissing this case as moot, the court permits our docket to be manipulated in a way that should not be countenanced. Now, personally, I think we can divide those concepts, right? Whether this case is moot and whether this is impermissibly manipulating our docket and therefore we should do something about it for that reason, I think are perfectly like legitimate things. So I wouldn't necessarily have to, at least in my own mind, conclude that the case isn't moot in order to conclude that we've been manipulated and perhaps we should be doing something because of the manipulation, like bad conduct by one of the parties. It wasn't in good faith, so therefore we have some remedy to deal with that as a court. That I would be on board with, but I don't necessarily think that you need the hook that it's moot or not moot to reach that decision. 12 years ago in the District of Columbia versus Heller, it has been a little bit now, yes. We held the Second Amendment protects the right of ordinary Americans to keep and bear arms. 2 years later, in our decision on McDonald versus Chicago, established this right is fully applicable to states. Since then, the lower courts have decided numerous cases involving Second Amendment challenges to a variety of federal, state, and local laws. Most have failed. We've been asked to review these decisions, but until this case, we've denied all such requests. And that could be due to a lot of reasons. Maybe the Supreme Court looking for the perfect case. I don't know, but that's where we are. On January the 22nd, 2019, we granted review to consider the constitutionality of a New York City ordinance that burdens the rights recognized in Heller. Among other things, the ordinance prohibited law-abiding New Yorkers with a license to keep a handgun in a home, a premise license, or for that matter, for a business premise license, from taking that weapon to a firing range outside the city. Instead, premise licensees wishing to gain or maintain the ability to use a weapon safely within were limited to 7 firearms ranges in the cities, all of which were largely restricted to members and guests. So it made it very hard to find somewhere to practice and become trained and competent and all that good stuff, In the district court and the court of appeals, the city vigorously, yes, they did. They certainly did. The city vigorously and successfully defended the constitutionality of its ordinance, and the law was upheld on basis of what we are told is the framework for review of the Second Amendment claims that has been uniformly adopted by the courts of appeal. One might have thought the city, having convinced the lower courts that the law was consistent with Heller, would have been willing to defend this victory in the court. But once we granted certiorari, both the city and the state of New York sprang into action to prevent us from deciding the case. They sure did. They sure did. Again, the whole thing was just like Benny Hill levels of comedy in terms of its way it happened. We love our law. We love our law. What's that? We hate our law. We hate our law. So, it's just very, very funny. So I definitely share the frustration of this opinion. Although the city had previously insisted, somewhat vociferously, might I add, that its ordinance served an important public safety purpose, our grant of review apparently led to an epiphany of sorts, and the city quickly changed its ordinance. Yeah. And for good measure, the state enacted a law making the old New York City ordinance illegal. Yep. Sure did. Did they prevent the Supreme Court from deciding it? They sure did. Thereafter, the city and amici supporting its position strove to have this case thrown out without briefing or argument. Yeah. The city moved for dismissal as soon as reasonably practical on the ground that it had no reason to file a brief, because you guys have won, even though we said our law was super wonderful. When we refused to jettison the case at that early stage, the city submitted a brief that stressed its true position was that it had no view at all regarding the constitutional questions presented, and it was offering a defense of the former rule in the spirit of something the court-appointed amici curiae might do. That's hilarious. We have no view as to our own law. We don't really have any view about that, but we'll just argue it like an amici curiae would. That's wonderful, man. I struggle to think of any other case or any other situation where I've seen anything like this happen. I'm struggling hard, by the way. A prominent brief supporting the city went further. 5 United States senators, 4 of whom are members of the bar of this court, filed a brief insisting that the case be dismissed. If the court did not do so, they intimidated the public would realize the court is motivated mainly by politics rather than adherence to the law. We all remember that when that happened, right? Yeah, we all remember that. That was, what's his name? Chuck Schumer, who stood outside and insinuated those things. Who said that? And of course would face the possibility of legislative reprisal. Brief for Senator Sheldon Whitehouse as well. Yeah, his brief was also really super special. Regrettably, the court now dismisses the case as moot. If the court were right on the law, I'd of course approve the disposition. Under our Constitution, our authority is limited to deciding actual cases or controversy. And this were no longer a live controversy, that is, if it were now moot, we'd be compelled to dismiss. But if a case is on our docket and we have jurisdiction, we have an obligation to decide it. As Chief Justice Marshall wrote for the court in Combs versus Virginia, we have no more right to decline the exercise of jurisdiction which is given than to usurp that which is not given. Well, that doesn't quite work because the United States Supreme Court declines the jurisdiction is given all the time. Like, all the time. Literally 99.3, 99.4% of the time. So, yeah, no, not so much, but okay. Thus, in this case, we apply the well-established standard for determining whether a case is moot, and under those standards, we still have a live case. It certainly is true the new ordinance and the new case give the petitioners most of what they sought, but that's not the case for mootness. Instead, the case becomes moot only when it's impossible for a court to grant any effectual relief whatsoever to a prevailing party. So they were holding on to those little crumbs that they thought were really left, holding on to those little bits to say it wasn't moot. I think they're reaching. And I don't think they have to reach to do what they're trying to do. Because I think saying one of the parties is playing games and trying to usurp the court and having good faith before the bad faith before the court could lead to its own set of remedies. So I think that it's not necessary for them to do what they're trying to do. As long as the parties have a concrete interest, however small, the case is not moot. Respondents have failed to meet this heavy burden. That is for two reasons. First, the changes to the city and state law do not provide petitioners with all the injunctive relief they sought. Second, if we reverse on the merits, the district court on remand could award damages to remedy the constitutional violation the petitioner suffered. New York State has a strict law governing the possession of firearms. With only a few exceptions, possession without a license is punishable by imprisonment and a fine. Local authorities administering this program in New York City, this is done by the New York City Police Department. New York City state law contemplates two primary forms of handgun license: a premise license, which allows a licensee to keep it at a home or business, and a carry license, which permits the licensee to carry a handgun. In this case, only premise licenses are at issue. Not a lot of concealed carry permits being issued by New York City, as you might imagine. Unless you're super important, then maybe. State law imposes an exacting standard for obtaining a premise license, and the licensing division subjects applicants to rigorous vetting. They really don't want to give you one, so they're going to make you jump through hoops to get it. Licenses may be issued only if, among other things, an applicant is of good moral character and no cause to exist for denial of licenses. Which, that doesn't sound so bad, but the rest of it's a little bit tedious and onerous. New York City residents must submit their applications in person at One Police Plaza in Manhattan. An applicant must pay a fee of $431 just to own a firearm, mind you. There are firearms that are cheaper than that. That is just for permission. So your permission slip costs $431.50. Must provide proof of age, citizenship, and residence, and must produce an original Social Security card. A completed application must specify the particular handgun the applicant wishes to possess, which I assume means the serial number of it, so you better know for sure, and address for which the licensee is sought. It must list all the applicant's residence and places of employment for 5 years. Why? Who knows? An applicant must answer questions about past arrests, summons, indictments, convictions, civil orders, and must respond to probing questions about drug use, subpoenas, testimony, unsuccessful applications for civil service positions, military service, mental illness, and physical conditions, such as epilepsy, diabetes, or any nervous disorder that could, in the judgment of the license division, interfere with the use of a handgun. So if you have absolute epilepsy or any sort of nervous condition, I guess you can't defend yourself. Okay, that's New York City for you guys. The applicant must explain where and how she will safeguard the handgun when not in use, and furnish the name and address of a state resident who will take custody of the handgun in the event of death or disability, which presumably has to go through its own background check. And these application requirements are only the beginning. The submission of an applicant triggers a rigorous police investigation into the applicant's mental health, criminal history, and moral character. A licensing official is required by law to review mental health records, investigate the truthfulness of the statements, and forward the applicant's fingerprints to the New York State Division of Criminal Justice and the FBI to determine if there's a criminal record. Under city law, grounds for denial include, among other things, any arrest, indictment, or conviction for a crime or violation in any state, federal, or local jurisdiction. So any arrest for any crime, anywhere. Not conviction, arrest. A poor driving history, why? Failure to pay debts, including child support and taxes, and untruthfulness. So I'm not sure why having a spotty driving record should in any way be relevant to whether or not you own a handgun. But, okay. The process, we're not done yet, kids. The process also includes an in-person interview, during which the license divisions may request additional paperwork. The video game's Papers, Please has nothing on these people. 2414 Commander says, is this what they mean by common sense gun laws? No, not exactly. It's not quite what they mean by common sense gun laws. They'd like more. But, you're on the right track. They haven't reached common sense gun laws, but they're on their way. They haven't gone quite there, but yeah, they're trying. So no, they'd like more. It takes the license division approximately 6 months to get permission to own a gun. Let's just remind you once again, just in case you forgot, this is not to own a concealed carry permit, which is a whole set of other licenses. This is just to own a gun in your home, which, you might remember from Heller and McDonald is a fundamental right. The city of New York would like to tell you a little bit about what it takes to get the right to own a handgun in your home. It takes the licensing division 6 months to process these applications, during which they cannot possess a handgun in a home, which I seem to recall vaguely was a fundamental right. When the license issues, this should be more like if, but when the license issues, an applicant wishes to obtain it, he or she must appear in person for at least a third time. At present, we're told approximately 40,000 residents, representing 1.29% of the city, has been issued handgun licenses, which I suppose says something for the spirit of people who really believe in the Second Amendment, really believe in their right to keep and bear arms. So I'm sure there have been quite a lot of people who haven't done it and given up along the way. But 1.3% of New Yorkers have said, I'm going to tough this out and see it through. So I'm slightly encouraged by that. It shows that there are people in New York who believe in their rights and are willing to exercise them. So cheers to you, 1.3% in New York City. You rock on. The New York Police Department may revoke these premise licenses at any time, which again reminds ourselves, fundamental right, but they can revoke it at any time for such things as laminating the license. Okay. And a license expires after 3 years, so a licensee who wants to continue to process a gun must file a renewal application, after which, presumably, you have to go through all this over again. I think the takeaway lesson here is don't move to New York City. The ordinance that the petitioners challenged in this case were adopted in 2001. Before then, the New York Police Department issued both premise license and so-called target licenses, which allow licensees to transport their handgun to specified pre-approved ranges. Target licenses were eliminated in 2001, and from that time until the changes now, premise licensees could practice with their handguns only if they directly traveled to and from an authorized small arms range shooting club, their guns were unloaded and secured in a locked container, and the ammunition was carried separately. Okay. And what is most important for our present purposes, the only authorized ranges in the city or clubs were ones that were located in New York City. At the relevant time, there were 7 such ranges in the entire city. 2 in Staten Island, 2 in Queens, 1 in Brooklyn, 1 in Manhattan, and 1 in Bronx. All but one generally admitted only members and their guests, and the only range open to the public was closed for a time due to the dependency of the case below. That's good news. So, you had to find a place to shoot. A lot of them were members only, which I assume meant, a lot more cash, among other things. And the one that was open to the public wasn't open to the public. New York City for you guys, ladies and gentlemen. New York City for you. In 2013, 3 individuals and 1 organization representing New York gun owners, that would be the New York State Pistol Rifle Association, the titular group of this case, brought suit under the statutes against the city and the police division, contending the restricted premises licensing violated their rights and other provisions of the Constitution. One of the individual petitioners, Romano Cataloni, has held a firearms license since 1979. Colonatone? I don't know. I'm doing my best over here. I'm not great with the Italian names. I'm so sorry. Colatoni, I'm going to go with. Colatoni currently has a premise license for his residence and wishes to take his handgun to ranges and competitions outside the city and to his second home in Hancock, New York. He refrained from doing so because of the ordinance that prohibited this travel. For example, Cataloni registered to participate in the 2012 World Class Steel Northeast Regional Championship in Old Bridge, New Jersey, about 20 miles from his home. He's a competition shooter, a man after my own heart. I've done a little bit of competition shooting, not much, but it's a lot of fun. But after the host of that competition alerted him that the premise license did not allow him to transport his handgun to New Jersey, and after Inspector Andrew Lunetta, the commanding officer of the New York License Division, confirmed this, Cataloni pulled out of the competition. So he couldn't take his handgun to do his competition because he couldn't transport it to the shooting range to do it. Calatone. Okay, great. Calatone. Thank you for Dogbert, or thank you, Eureka. Colatone. I'll try to get it right. Thank you. Plaintiff Efren Alvarez has had a firearms license for approximately 30 years, and plaintiff Jose Anthony Izaray has been licensed for 15 years. Both men would like to take their handguns to ranges and competitions outside the cities, but they've not done so because of the same ordinance. After their host previously noted the competition in New Jersey and advised them that their license barred them from taking their handguns outside the city, they both decided not to attend. For the same reason, Alvarez also did not participate in the International Defense Pistol Association postal matches. IDPA. I have done IDPA. I prefer USPSA, but IDPA is also a well-understood, well-known competition. So if you're looking to do competition pistol shooting, IDPA and USPSA are your 2 major groups. And IDPA is the group he did. Fine. All 3 individual participants aver that they regularly travel to ranges outside the city to ranges and championships before learning of these restrictions. So they offer that they have broken the law. The petitioner's amended complaint maintains the Second Amendment requires unrestricted access to gun ranges and shooting events in order to practice and perfect gun handling skills. So that's where this is going to break down. He's going to argue it's not moot because it's not unrestricted. Okay. The complaint asserts this practice is necessary for safe and responsible use of firearms for self-defense and defense of one's homes. And the New York City ordinance backs this up, providing that licensees should endeavor to engage in periodic handgun practice at an authorized club. Not that we've made it easy. So we'd like you to practice, but we don't want you to practice because we're not going to let you practice anywhere. Good stuff. According to the complaint, the city, by limiting licensees like petitioner to 7 ranges, imposes serious burden on the exercise, particularly when most of those clubs are not open to the public, require huge membership fees, and so forth and so on, and the other one is closed. Yeah, that's a problem. The amended complaint's prayer for relief sought an injunction against the enforcement of these travel restrictions, as well as attorney's fees, costs of suit, declaratory relief, and any such further relief as the court deems just and proper, which you always throw in every lawsuit, and occasionally you will see a court use this as a linchpin to do something. And that's what these three people wanted. These three justices wanted to do. They wanted to use that because they say, well, they haven't gotten complete relief because they've asked for other relief, that unspecified relief, which, is an interesting legal trick. But I don't know. It's not really in keeping with the case law, but it's a nice try. 3 justices went for it, though. So, hey, The city vigorously defended this law. The ordinance did not impinge on the petitioner's Second Amendment right, the city told the lower courts, and even if it did, it survived the heightened scrutiny. This was so the city maintained because the travel restrictions were necessary to protect public safety insofar as the transportation of firearms outside the home potentially endangers the public. To support this assertion, the city relied on a declaration of the Inspector Lunetta, which attempted to explain why the restrictions were necessary to address public safety. Lunetta justified the law in 3 ways. First, he maintained the restriction on out-of-city transport promoted public safety by causing premise licensees to bring their firearms into public domains less frequently. I'm not sure how that quite works, but okay. Second, he claimed the transport restriction helped to prevent gun violence that might occur if the licensee became involved in an altercation while on the way to an out-of-city range, even though it had to be in a hard case and the ammo had to be carried separately. Lunetta asserted that licensees are susceptible as anyone else to stress-inducing circumstances that can lead to violence. That would make them, open up their lock case, get the gun, get the ammo out somewhere else, load the gun, and do stuff or whatever. I don't know. Okay. Finally, he claimed the travel restriction made it simple for a patrol officer to check whether a holder of a premise license who's found in possession of a gun outside the home is really headed for a range or simply using it as a pretext. He declared that there were several reported cases where holders of premise licenses were charged with criminal possession when found with their firearms while not en route to a range. He cited 5 cases, but not one of the opinions that the licensees claimed to be headed to a range or competition outside the city. Yeah, good times. The district court denied the petitioner's motion for preliminary injunction and summary judgment and granted the city's cross motion for summary judgment. The district court did not deem any burden on the petitioner's Second Amendment right minimal or at most modest. The district court doesn't particularly care. The district court does not give a fuck. And the court credited the city's public safety rationale, citing Lunetta's declaration approvingly and discussing the importance of the travel restrictions and limiting the movement of licensees with their handguns. The Second Circuit affirmed the panel declared the ordinance burdens the petitioner's rights as trivial and expressly credited Lunetta's explanation of the public safety purpose served by these restrictions. When petitioners filed a petition for certiorari, the city opposed review, contending, among other things, the travel court restriction promotes the public safety, as demonstrated by Lunetta's declaration. We nevertheless granted review, and this, as noted, apparently led the city to reconsider whether it was actually needed for public safety purposes. So despite all those declarations, despite all that fight, we simply said, we've seen the light. We don't have to do this after all. What an amazing coincidence. On April the 12th, New York City Police, thank you, Shannon Davis, for becoming a supporter of the channel. It is appreciated. Thank you. On April the 12th, the New York Police Department published a proposed amendment to the travel restriction that was admittedly spurred at least and part of granting review. Under this amendment, the holders of premise licenses will be allowed to take their guns to ranges, competitions, and second homes outside the city, provided that the licensees travel directly between the residence and the permitted destination. After a period of notice and comment, the proposed amendment was adopted on June 21st and took effect on July 21st. We are balling to get this adopted. Our grant of certiorari also prompted action by New York State. With the support of the city, the legislature enacted a new law abrogating any local law, rule, or regulation that prevented the holder of a premise license from transporting a licensed handgun directly to or from an authorized range, competition, or second home. So yeah, as I have said many times, they thought their law was great until it wasn't. Then they went running and screaming, and they got someone to adopt a different law. So, Super duper interesting. Shortly after the new state law took effect, the city filed a suggestion of mootness, asking us to vacate the decision below and remand with instruction to dismiss. The city urged us to rule on this matter expeditiously, so it not be required to file a brief defending its prior law. When we refused to vacate, the city protested that briefing on the merits required the city to do what Article 3 case or controversy requirements designed to avoid: engage in litigation that regards the constitutionality of a law that no longer exists, and the city would no longer react. Hilarious. When the case was argued, counsel for the city was asked whether the repeal of the travel restriction had made the city any less safe, and his unequivocal answer was no. Very hilarious. So, the city attorney said, "Did this make you any less safe?" "No, we're good." So the old law wasn't really about safety, was it? Yeah, the repeal of it didn't make us any less safe, so the old rule didn't make you any more safe, so it wasn't really about safety. Now, my friends, if the old rule wasn't really about safety, what could it have possibly been about? I don't know. The court vacates the judgment of the Court of Appeals, apparently on the case that the grounds that another case is another moot. Other than mootness, no basis for vacating comes to mind, and therefore I proceed on that assumption. And if that is the reason for what the court has done, the court is wrong. This case is not moot. Article 3, Section 2 of the Constitution limits the jurisdiction about two federal courts to cases in controversy, and as a result, we may not decide questions that cannot affect the rights of litigants before us. Nor may we advise what the law would be under a hypothetical state of facts. This means the dispute between the parties in a case must remain alive until its ultimate disposition. If a live case ceases to exist, if the case becomes moot, we have no jurisdiction. But in order for that to happen, a case must really be dead, and noted that only occurs when it's impossible for a court to grant any effectual relief whatsoever to any prevailing party. As long as the parties have any concrete interest, however small, in the outcome, the case is not moot. Thus, to establish mootness, a demanding standard must be met. So they're holding on to those little crumbs, man. Holding on to those crumbs. We have been particularly aware of attempts by parties to manufacture mootness in order to evade review. And it's black letter law that we have virtually unflagging obligation to exercise our jurisdiction. I don't think you want to say that because, yeah. In this case, the amended city ordinance and their new state law give petitioners most of what they sought, but new laws do not give them complete relief. It's entirely possible for them to obtain more relief, and therefore this case is not moot. This is for the following reasons. Oh yeah, I have no problem believing the membership fees are pretty expensive. Although $200 per year sounds pretty reasonable when you've already paid $435 just for the right to own the gun. So $200 for a membership purchase isn't actually that bad. So, First, this case, I'm not saying that you should have to spend it. I'm just saying that in the grand scheme of the amount of fees and time, it's not that bad for $200. I don't think you should have to spend it. I'm not saying that's relevant to legal issues. I'm just making kind of a factual observation. If you already spent $435 for the initial application fee and gone through 6 months and a couple appearances, and that's my point. Moving on. First, this case is not moved because the amended city ordinance and state law do not give petitioners all the prospective relief they seek. Petitioners assert that the Second Amendment guarantees them, as holders of premise licenses, unrestricted access, and the new laws do not give them that. The new city ordinance has limitations that petitioners claim are unconstitutional, namely a trip outside the city must be direct, and travel within the city must be continuous and uninterrupted. Exactly what these restrictions means is not clear from the face of the rule, and the city has done little class to clarify the reach. At argument, counsel told us the new rule allows for bathroom breaks, coffee stops, and other stops that are reasonably necessary in the course of travel. But what is the meaning of reasonably necessary? What about a stop to buy groceries? Or a stop to pick up a friend who wants to practice? Or a quick visit to a sick relative? The city does not know the answer to such questions. Yeah. Based on all this, we're left with no clear idea where the city draws the line. The situation is further complicated by the overlay state law. The new state law appears to prevent the city from penalizing any direct trip to the range or competition, but the state law does not define that limitation. The petitioner wants to enter a competition upstate New York, more than 5 hours drive. Could they stop along the way? And if so, for how long? The state has not explained its understanding of the new limitation. In any event, prosecutorial discretions are generally made by 67 elected district attorneys. Hilarious. That's true. The bottom line is petitioners who sought unrestricted access are still subject to restrictions that undermine their meaning. These restrictions may not seem very important, but that's besides the point for mootness. Nor does it matter where in the end these restrictions would be found to violate the Second Amendment. All that matters for the present purpose is that the city still withholds from petitioners something they have claimed to begin is their constitutional right. If files the case, it's not moot. It's as simple as that. Yeah, I mean, the other cases have not done a really good. The other opinions have not done a really good job of rebutting this. And, it is a point that's valid. They did ask for unlimited and they didn't get it. These restrictions are unclear, that there's still limits and they're unclear. So is the case moot or not? It's tough, actually. I'm trying to decide in my own head right now. Yeah, I don't know. They make a pretty persuasive case. So then if I were trying to decide this, I'd be interested in the pragmatic issues. So this is a philosophical rationale, right? This is all a philosophical rationale for why the court still has power to act. So then my next question going through my head would be like, what happens if we do? What would we be issuing? What would we be doing pragmatically in terms of relief or otherwise, right? So that'd be another thing I'd be going through my head. Like, is there a reason for us to keep jurisdiction? And I don't like these citations. I don't like these citations of we must do everything that's within our jurisdiction. Guys, you dismiss 99.6, 99.3% of all cases every year before they ever hit the ground. If you have an obligation to hear every case that's in your jurisdiction, you're doing a really bad job of it. So don't give me, we must hear this case because it's in our jurisdiction. It is our duty to hear this case. Don't give me that. Don't give me that. You don't hear cases all the time. The situation here resembles Knox. The issue in that case is where a public sector union had provided non-members a sort of notice or case law required before they could be forced to pay a fee to subsidize union activities. We grant certiorari to review the Ninth Circuit's holding. The notice the union had provided was sufficient. Before we could decide the case, the union sent out new notices and moved to dismiss. The employees objected the new notice was inadequate, and we refused to dismiss. In doing so, we did not apply about the adequacy of the new notice, but simply held the case was not moot because there was still a live controversy as to the adequacy of the original notice. Although the new notice might have given non-members most of what they sought, they still possessed a concrete interest, however small, in the outcome of the original litigation, and what was enough. The situation here is essential. Petitioners got most, but not all, the prospective relief they wanted. That means the case is dead. Question in the chat. Can Congress demand the Supreme Court take a case? Yes, as a matter of fact, they can. The Supreme Court has changed the Supreme Court's appellate jurisdiction over the years. The Supreme Court, I think, was obligated to take all cases for a while, and then, the circuit courts were more established. But long story, yes, the Supreme Court could force the U.S. Supreme Court. I apologize. Congress could force the Supreme Court to take cases. Yes. By changing the rules on it, right? So most cases come up through this discretionary review, writ of certiorari. There are a couple things that are mandatory on appeal. Three district panels, most notably being district king cases. Those are mandatory. And original jurisdiction cases, which are very far and few between, but they're mandatory. So yeah, this is the Congress could make it mandatory. I'm not sure they could mandate that the Supreme Court take a particular case, but they could mandate them taking classes of cases. The case is not moot for separate and independent reasons. If the court were to hold as petitioner's request, and I believe they should, the statute violated the petitioner's Second Amendment right, the district court on remand and probably should award damages. And while the amended complaint does not seek damages, it's enough that it requests any further action. Among modern pleading standards, that suffices. Good evening, Evil Treble. Nice to have you here. Retired cops get licenses because there's a federal law that says they do. I'm trying to remember the name of the federal law. But as I recall vaguely, if you're a cop for 25 years, you can get a license, or you can carry already on your license as a cop or something. It's been a while since I read the statute, but there's a federal law dealing with that. Also, a favor to, a brother in arms and all the rest of it. The Federal Civil Procedures provides that final judgment should be granted to relief in which each party is entitled, even if the party does not demand that relief in pleadings. The courts have refused to award relief outside pleadings only without somehow prejudice the defendant, such as when the defendant did not have an opportunity to contest the basis for relief. Otherwise, a party should experience little difficulty in securing a remedy other than by demanding it in pleadings so long as the party shows a right to it, and here that could include damages. It was 10 years. Thank you for the correction. I told you it had been a while since I read it, so. At a minimum, if petitioners succeed on their challenge to travel restrictions, they'd be eligible for nominal damages, which is, literally $1, but, whatever. When petitioners' constitutional rights have been violated, nominal damages may be awarded without proof of additional injury. Nominal damages are appropriate means of vindicating rights whose deprivation has not caused an actual provable injury, and are particularly important in vindicating constitutional interests. Consequently, court routinely award nominal damages for constitutional violations. And it's widely recognized that a claim for nominal damages precludes mootness. So I guess you should have asked for nominal damages, like our heroine did in her case with her First Amendment challenge in Wisconsin. Incidentally, I did fax the sheriff's office this morning. I didn't hear anything back. If I don't hear anything back tomorrow, I'll send them an email on Wednesday and see if that gets me anywhere. It's even possible that one or more petitioners may be eligible for compensatory damages. To get such relief, they'd be required to show they'd suffered an actual injury, but petitioners may be able to show the showing. As discussed above, the failure to include in their complaint specific allegations would not preclude the recovery. Nor would petitioners obligated to provide information supporting actual injury in opposition to the motion for summary judgment. If we were to reverse judgment below and hold the court's rule unconditional, it'd be appropriate to remand the case for proceedings on questions of remedies. We have frequently done this when reversing a judgment that was entitled to plaintiff on liability grounds. Hey, Dave, how you doing? Nice to have you here. Fax Boomer. It's silly as the law moves slow. So I don't like to use fax. It's just that lawyers as a profession use fax. So, I don't, it's just, we're the profession like the law itself is slow to move. So, the law is super uber boomer. Yeah, that's right. I have to talk to lawyers who are still practicing in their 80s. So, what you gonna do? If it makes you feel any better, I don't actually have a fax machine. I have a virtual fax number, like a civilized person. With this in mind, the possibility of actual damages cannot be ruled out. One or more of the petitioners could seek compensation for out-of-pocket expenses, such as membership fees at in-city ranges. The current record shows at least one of the petitioners is a member of a range of the city. In addition, a petitioner may be entitled to compensation for expenses incurred in registering for out-of-city competition, for which they're compelled to withdraw. I like that. Getting damages for the fees that you incurred. That's nice. The record shows that one petitioner signed up for such a competition but had to pull out. Petitioners could also seek compensation for any intangible but necessarily real and personal injury they suffered. Non-economic damages such as loss of enjoyment are available in 1983 litigation. I know you guys, well, some of you guys may be frustrated, but it is probably a good thing the law moves slow and is very predictable so that everyone knows where we are. I'm not so sure it's great in Second Amendment litigation specifically, but that everything takes a while is kind of, it feeds predictability. so that people can operate. So it's probably on the whole good thing, even if it's a little frustrating and silly at times. Okay, that's cool, Dave. Did he say anything in response to that comment, or did he immediately ban you, or what? Just out of raw curiosity. Law, yeah. Lower courts have affirmed awards of compensation for similar kinds of injuries resulting from constitutional violations. Petitioner could introduce evidence on remand for showing such loss. For the purposes of determining whether a case is moot, the question is not whether they would actually succeed or whether the losses were substantial. If there's any possibility of damages, the case is not moot. Yeah, I think there's a technical case to be made that it's moot. Apologize. There's a technical case to be made that's not moot. Um, so I'm not saying that what they're saying is wrong. I think they're just frustrated. That's what I'd say. They're frustrated, and rightfully so. I think they're frustrated. They're frustrated because of this, and I think rightfully so. And they're using this as a mechanism to deal with their frustration. And I understand that. But I think the issue, the way to solve this problem, at least in my humble opinion, the way to solve this problem is to grant a couple different cases. The Supreme Court every year hears a couple First Amendment cases. I'm struggling to think of any year where they haven't heard at least one, and it's not unusual for them to hear 2, 3, 4 First Amendment cases every year. So why not grant certain 5 different Second Amendment cases? We certainly need the development of law. We could do that. That'd be good. The overall acceptance rate of the Supreme Court has been coming down a little bit in recent years, so they have the bandwidth space to deal with it, versus like historical practice. So it's not like they're slammed to the wall, versus what they've been doing historically. They have the space to deal with it. I don't know. I think it's I think it's kind of behind the scenes politics is what I think is going on, right? It's like the votes are a little bit tenuous. So the votes are a little bit tenuous. So if you the best thing the gun rights, well, I don't know if it's the best thing the gun rights people could have for, because it would have serious political ramifications. But let me just say this a different way. If Ruth Bader Ginsburg for any reason should leave the bench, then Trump would be insane to nominate anyone other than Amy Coney Barrett. And if Amy Coney Barrett, who I believe is currently a judge on the 7th Circuit, she's a judge somewhere, I think it's 7th. If Amy Coney Barrett gets confirmed, she's more conservative than Thomas. So you'll have all the votes you need. Now, what that will mean for the future, for the court, and the Democrats and them trying to pack the court and blah, 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 whatever, is a whole other set of problems. But that would be nice. Roberts is a pragmatist, and he's also concerned about the legitimacy of the court. And that's not necessarily bad, but it leads him to not make decisions that are as conservative as you might like, because he's making decisions more to preserve the institution and pragmatically. And you saw that, if nowhere other than the Obamacare decisions, right? That was a very clever decision to solve a problem that he wanted because he thought it was important for the legitimacy of the court. So he answers questions that way. So for all the left-leaning people that think that Roe versus Wade or Casey versus Planned Parenthood are in jeopardy, I don't think so. I don't think Roberts has a vote to overturn those. I just don't see it happening. And for the same reason, he's not one to stick his neck out here either. So I think that's part of the problem behind the scenes. Now, that being said, there is an interesting little quirk of Supreme Court rules. And that quirk is that in order to get a case heard by the United States Supreme Court, you only need 4 votes. It's called the Rule of 4 because we're not creative in naming anything. To ultimately decide the issue, you need 5 votes. But to hear the case, you need 4. And so you have 4 votes. You have Kavanaugh and these 3. So you have 4 votes that say we want to hear court cases. But maybe they're looking for the right case because they're concerned about where Roberts would be. There's no reason to hear a case if it's going to go the wrong way. So maybe they're holding back because they're concerned about where Roberts is going to be. That could be a reasonable concern. I'm just Amy Coney Barrett. What did I say? I said Amy Coney Barrett. I said something along those lines. Did I say Cohen instead of Conan? Coney? I said Cohen instead of Coney. Fair. Sorry. I said Amy Cohen Barrett instead of Amy Conan Barrett. You're right. I said Cohen instead of Coney. You're right. Amy Cohen Barrett. Coney Barrett. Yeah, that's right. Yeah, okay. Sorry for the slight mispronunciation there. But yeah, I think that's probably what's going on if I had to guess behind the scenes of trying to figure this out. Coney. Yeah, Coney. I got it. I'm on board. I got it. Jack asked, does she like stare decisis? Jack asked, does Amy Coney Barrett, like stare decisis? No. 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 No, she doesn't. No. One final point about damages must be addressed. We have warned and dictated that claims of damages asserted solely to avoid otherwise certain mootness bears close inspection. But after close inspection, we conclude the stringent test for mootness is not met. We have no authority to dismiss on this ground. Nothing in Arizonans for official English suggests otherwise. In that case, plaintiff, who was an employee of the state of Arizona when she filed her complaint, sued the state under 1983. Claiming the state's constitutional amendment declared English the official language of the state, unconstitutionally prevented her from using Spanish to do her job. Not quite sure how, but whatever. Her class for declaratory injunction became moot when she left state employment for the private sector, and we held her request for nominal damages from the state to not save her case from mootness, since the state may not be sued under 1983. The situation is here because nothing blocks the award of damages from the city. Yeah. Relief would be particularly appropriate here because the city's litigation strategy caused petitioners to incur what are surely very substantial attorney fees in challenging the constitutionality of city ordinance the city went to great lengths to defend. Of course, a claim for attorney's fees is not alone sufficient to preserve a live controversy. But where a live controversy remains, a defendant who would otherwise be liable for attorney's fees should not be able to wiggle on the basis of a spurious claim of mootness. If 1983 plaintiff achieves any success on the merits, even award nominal damages, a plaintiff is entitled to prevailing parties entitled to attorney's fees. Now, that is very, very true under the statute for 1983. So even if they had gone $1, it would have given them attorney's fees, which would have been really, really nice because this cost them a shit ton of money. So that's as good a reason as any to maintain it, I guess. Yeah. Apparently, I did see like one report. Apparently, Ruth Bader Ginsburg is still working at the gym with her trainer. Now her building has a gym, but apparently it's available to her and she's still working. Or maybe she's working out the Supreme Court gym. I'm not sure, but either way, she's still going to the gym. The Supreme Court has a basketball court. Do you guys know that? It's on the top floor of the Supreme Court. I've never seen it, but it's there. So maybe she was working out there. They call it the highest court in the land because of course they do. Because it's on the upper floor of the Supreme Court. The highest court in the land. The basketball court. That's the joke. On the other hand, dismissing the case as moot means the petitioners are stuck with attorney's fees and encourage a challenge to the rule the city's ultimately abandoned and now admits were not needed for public safety. That is so because it defends voluntary change in conduct, although perhaps accomplishing what the parties sought to accomplish lacked the necessary of the judicial imprimatur of the change. That's very cute. Yeah, it is absolutely one of those oral argument jokes that everyone has to laugh at or else. You are absolutely correct. Evil Triple, 100%. You are correct. $2 from collector, a gym or a life support system. Very cute. Very good. At this point in the stream, because, maybe some of you guys don't know about them, we have memberships. We now have memberships. On your screen, there might be a join button somewhere next to the subscribe button. And if you click the little join button, you can become a member and your name can become green and you get a cool little icon and I will like you better. So, you can become a member and join for a low, low price of $1. For you, my friend, special price, $1. $1. Thus ends the plug. The section's attorney's fees are an important component of civil rights. The prospect of an award of attorney's fees ensures that private attorneys general can enforce civil rights through litigation, even if they cannot afford legal counsel. Well, Zafal, you must have figured it out because your name isn't green. So you figured it out some way. So, Here the city's fought petitioners tooth and nail in the district court and the Court of Appeals, insisting that its old ordinance serves an important public safety purpose. When petitioners sought review in this court, the city opposed certiorari on the same ground. But once we granted review, the city essentially attempted to impose a unilateral settlement that deprived the petitioners of attorney's fees. Click the leave button and you'll see it again. Oh, yeah, that might be true because you already joined. So you won't have a join button because you won't have a leave button. Please don't click the leave button. I want you to be my I want you to be my friend. I will sing to you. Or in the alternative, I will not sing to you. Whatever will make your membership bloom. The per curiam opinion provides no sound reason for holding the case as moot. The per curiam states the city's current rule gave petitioners precise relief they requested, but that's not so. Petitioners' prayer for relief asked the court to enjoin, insofar as it prohibits travel outside the city to ranges, competition, and second homes. The new rule unmistakably continues to prohibit some travel outside the city to these destinations. For this reason, petitioners have not obtained unrestricted access they maintain the Second Amendment guarantees. The per curiam implies the current rule, as interpreted oral argument, gives petitioners everything they seek, but that is not true. Thank you, Marauder, for joining. Thank you, Zion, for joining. You are uncivilians. Yes. If you become a member and get the green thing, you can call yourself an uncivilian. So you can become an uncivilian and part of the uncivilian army or whatever. The uncivilian militia. Ooh, even better. Thank you, Bart, for your support. It is appreciated. Thank you. Petitioners still claim the right of unrestricted access, and counsel's off-the-cuff concessions did not give them that. The per curiam's main argument appears to go as follows. Petitioners' old claim was a challenge to New York's old rule, and the claim is now moot due to the repeal of the rule, and what petitioners are asserting is a new claim, that the current rule is also unconstitutional. This argument also misrepresents the nature of the claim asserted. What petitioners claim in their complaint, thank you, A. Hedinger, for your support. It is super appreciated. Thank you. What petitioners claim in their complaint and still claim is that they're entitled to unrestricted access to out-of-city ranges and competitions. The city's replacement of one law denying unrestricted access with another that also denies that access did not change the nature of the claims or render it moot. Yeah, see, you get an icon and everything. You get a cool icon, and you get access to previous batch recording live streams. And, if I figure out other membership benefits, maybe you'll get those someday too. Consider what acceptance of argument adopted by the per curiam leads. Suppose the city council, seeking to suppress a local paper's opposition to some of its programs, adopts an ordinance prohibiting the publication of any editorial without approval. Suppose this newspaper challenges the constitutionality of this rule, arguing the First Amendment confers unrestricted right to editorialize. If the council repeals its ordinance and replaces it with a new one, requiring approval only if the editorial concerns one particular program, would that render the program moot and require commencing a new one? Or take this example. It's always nice to throw these examples in the other side's face. A state enacts a law providing any woman wishing to take an abortion must submit to a certification by 5 doctors the procedure is medically necessary. After a woman sues claiming any requirement of certification is unconstitutional, the state replaces its old law with a new one requiring certification by 3 physicians. Will the court be required to dismiss this suit? Suppose the court, by following the precedent set by today's decision, holds the case as moot, and so the woman brings a second case challenging the new law on the same ground. The state repeals that law and replaces it with one requiring certification by 2 cases, 2 doctors. Would that be moot? And what if the state responds to that by enacting one that only requires 1? Mootness doctrine does not require such results. A challenge to an allegedly unconstitutional law does not become moot with the enactment of new legislation that reduces but does not eliminate the original injury alleged, and that's the situation here. The court cites one case in support of its holding, Lewis versus Continental Bank, but that decision is wholly inopposite. The situation in Lewis was complicated, but the critical point for the present purposes is that by the time the case reached the court, the enactment of new legislation meant the plaintiff no longer had the Article 3 standing. Excuse me. But instead of simply ordering the case be dismissed, the court remanded to give the plaintiff the opportunity to assert a different claim and, if necessary, amend the complaint or develop the record. The situation here is different. It's not disputed that petitioners have standing to contest the city's restrictions on the trips of out-of-city ranges of competition. As a result, the petitioners have suffered and will continue to suffer injury. They're now asserting a new claim. The original claim is that they have the right under the Second Amendment for unrestricted access, and this claim does not require an amendment to challenge. For these reasons, there's no justification regarding it as moot. Again, to me, it just strikes me as that they're frustrated. But again, I think this could be solved by just granting some more cases. There's plenty ready to go. The surly Sasquatch says, welcome to being a supporter. Now, the surly Sasquatch. I can't help but thinking that I saw your name pop up earlier as a new member. Is it at all possible you left and then became a member again? But either way, I'm happy to have your support. Thank you. Having shown this case is not moot, I proceed to merits of the claim. The city ordinance violated the Second Amendment. That's not a close question. The answer follows directly from Heller. Oh, super chat from earlier. Fair enough. In Heller, we had a District of Columbia rule that effectively prevented a law-abiding citizen from keeping a handgun in the home for the purposes of self-defense, and that constituted a violation of the core right of the Second Amendment. Yeah, there are a whole bunch of CCW reasonable needs cases to be discussed. Yeah, I'm telling you, there's plenty of cases that are available to discuss, man. I mean, there's plenty of cases ready to go. Let's do it. Let's do this thing. We base this decision on the scope of the right to keep and bear arms as understood at the time of the adoption. We recognize that history supports the constitutionality of some of these laws, limiting the ability to purchase a firearm, such as laws banning firearms from certain sensitive locations, quoting McDonald and Heller, but that we see no history provide no support for the laws like the districts. For similar reasons, this statute also violates the Second Amendment right. We deal here with the same core right, the right to keep a handgun in the home, and the Second Circuit assumed a necessary condition is the right to take it for certain purposes. One of these is to take a gun for maintenance or repair, which the city allows. Another is to take the gun outside the home in order to transport lawfully, which the city also allows. And still another is to take the gun to a range in order to gain and maintain the skill necessary to use it responsibly. As we said in Heller, that to bear arms implies something more than merely keeping it. It implies learning to handle and use them in a way that makes them readily for their efficient use, which goes back to the whole regulated militia thing in the original sense of regulated, which is orderly and working. We want people to be able to use it in a way that's effective. It's true that a lawful gun owner can sometimes practice at a range using a gun that's owned and rented by some at the range, but that same model gun the person owns may not be available at the range. In any event, each individual gun may have its own characteristics. They certainly do. Once it's recognized the right at issue is concomitant of the same right recognized in Heller, it becomes incumbent on the city to justify its restrictions on the rule it imposes, but the city has not done so. It points to no evidence of laws of force around the time of adoption that prevent gun owners from practicing outside the limits. The city argues that municipalities restricted the places within their jurisdiction where guns could be fired, and observes the Second Amendment did not mean that city residents with a premise license can practice in Central Park or Times Square. That's certainly true, but that's not the question. Petitioners do not claim their right to fire weapons in public places within the city. Instead, they claim their right to practice specifically outside the city, which is nice too. Very true. If history is not sufficient to show New York City's ordinance is unconstitutional, any doubt is dispelled by the weakness of the showing that travel restrictions significantly promote public safety. Although the courts below claimed to have applied heightened scrutiny, there was nothing heightened about what they did. Nice burn. D. Peterson says, I want to let you know I chose Uncivil Law over HVAR/R videos for live viewing tonight. I don't know what those things are, but thank you for choosing me. Your attendance is appreciated. I also take some note that I was also upstaged by my friend Leonard, who I'd like to note, for the record, announced his live stream after I announced mine. So, yeah. Yeah. At note, the cities relied entirely on the declaration of the inspector, but the declaration provides little support. Some of which the inspector Lunetta asserted was simply not relevant to the justification for drawing a distinction between the trips to range the city and trips to range a neighboring destination. Yeah, I did beat him by a couple minutes. It wasn't like a lot of time, but I did announce mine first, and then he announced mine on top of mine for the exact same time. Which Viva's here. Where's Viva? Viva's here. I didn't see him. Is he here? Where are you at, Viva? Where are you at? Nice to have you, Isaac. C relied entirely on the declaration of the declaration, but the declaration provided little support. Some of what the inspector asserted was simply not relevant to justification for drawing a distinction. Oh, Viva's streaming too? Viva's also upstaging me? I can't win. That's good. That's good news. That's great. That's true. Last time you told me that, he wasn't really streaming. Are you sure he's really streaming this time? Are you sure? Let's find out. Yeah, apparently he is. All right, I'm going into his chat real fast. Hold on. I'm going into his chat and I'm harassing him. All right, back to where we were. Some of what the inspector asserted was simply not relevant to the justification for drawing a distinction between the trips to range in the city and trips to range in a neighboring destination. For example, he stated that persons holding premises licenses do not always transport their firearms in the lockbox, carrying ammunition separately as required by the rules. Can't get no respect around here. Similarly, he declared premise license holders have not demonstrated proper cause to carry a concealed firearm, but the question before us is whether petitioners have the right to do so if they could carry licenses. Other statements actually undermine the city's public safety. Thus, the fact that prosecutors typically do not bring even misdemeanor charges against licensees who carry a weapon in violation of their license. Other licensees do not suggest the city regards licenses as presenting a particularly significant threat to public safety. When all that is irrelevant is brushed aside, what remains are three arguments noted earlier. First, Inspector Lunetta's asserted the travel inspections discouraged licenses from taking their guns outside the home, but this is a strange argument for several reasons. It makes sense only if less convenient or more expensive to practice at a range in the city. But that contradicts the city's argument that 7 ranges provide ample opportunity for practice. Sure they do. And discouraging trips to range contradicts the city's own rule recommending licensed practices. Once it's recognized that a reasonable opportunity to practice is part of the recognized right in Heller, what amounts to that is a repudiation of what we held in that decision. Ouch. Second, Inspector Lunetta claims his prohibiting trips to out-of-city ranges helps to prevent a person who's taking a gun to a range from using it in the fit of range after an auto accident or some other altercation that occurs along the way. And to bolster this argument, Inspector Lunetta asserts a person who's met the city's the city's demanding requirements for obtaining a permit license are just as likely as anyone else to use the fit of rage. If that's so, it does not reflect well the city's intensive vetting scheme, and in any event, the assertion is dubious on its face. More to the point, the argument does not explain why a person headed to the range outside the city is any more likely to engage in such a conduct as such a person whose destination is a range inside the city. As might be something to this argument if ranges in the city were closer than those outside its border, but the city never attempted to show that. The courts below were incurious about the validity of the assertion, and given the locality of the 7 ranges, the assertion is dubious. Viva Fry apologizes for streaming at the same time. Thank you. Well, it's not like he isn't subscribed to me and he can't see me in his subscription feed, but still, it's fine. It's all for fun. It's all for fun, I go there to tease him. I'm not actually mad at him. When I'm done here, maybe I'll go on Viva Stream. I'm absolutely, by the way, trying to barge into Viva Stream when I'm done with this stream. And then if I make it onto the stream, I'm absolutely going to harass him about it because, of course, I am. Because that's how I show my love. But I'm not actually mad at him. I consider him my friend, and he's every right to stream I do. I'm a little bit irritated at Leonard, just because I announced it, and he knew I announced it because it was on his Discord, and he scheduled it for the same time, and he knew. I'm a little bit. Just because I don't think he would have very much appreciated it if it were the other way around. But, yeah. Anyways, pressing on. Inspector Lunetta's final justification for his travel restriction was only marginally stronger. It goes like this. Suppose a patrol officer stops a premises license and finds an individual carrying a gun, and suppose the license says he's taking a gun to a range to practice or is returning from a range. If the range in question is in one city, will the officer be better able to detect the story that the range is outside the jurisdiction? How strong is this argument? The city presumably has access to records of cases in which licensees were cited for unauthorized possession of guns outside the home and failed to provide any evidence that the holders of target licenses have used their right to practice at out-of-city ranges at a pretext. And it's dubious that it would be much harder for an officer to check whether a licensee was really headed for out-of-city range as opposed to one in the city. If the licensee claims to be headed for a range in the city, the officer can check whether the range is open and whether the individual appears to be on a route that plausibly leads to it. But how much more difficult would it be to do the same thing if the range is one of the counties that borders New York or across the Hudson River in New Jersey? A phone call would be enough to determine the range's operating hours, and the route would be still easy enough to determine. There are only a few bridges and tunnels through New Jersey, and just a few main thoroughfares to neighborhood counties. A court conducting any form of serious scrutiny would demand the city provide some substantiation of the claim, but nothing like that was provided and demanded. Would the situation be much different if an individual claimed to be at home from the range? Once again, it would not be difficult for an officer to check whether the range was or recently had been open. It's not all apparent to determine where a licensee was on the route to his residence. Thank you, Repudiator, for your support is appreciated. $5 from Newbie. In V's defense, I didn't get enough. Yeah, the YouTube defense thing is a whole. Yeah, the YouTube notification thing is a whole nother level of problem. But yeah, in Viva's defense, I didn't get notification until 15 minutes ago for your stream. Still didn't get one for Leonard. I did schedule this with. I'm trying to remember. Was it about an hour's notice or it was 45 minutes notice, something like that? So I did try to schedule it with a little bit of notice, but does Viva, does YouTube put out my notices? No, of course not. You have to hit the bell and you have to hit the all, and I don't know. Maybe if you're members, you get notifications. I don't know. Maybe members get notifications. Maybe that's a perk of membership. I don't know. Because otherwise YouTube doesn't want to share nice with others. Inspector Lunetta's declaration shares that ranges in the city are required to keep a range record of everyone who practices there, and therefore a person coming from a city range, the officer could check the story. But declaration does not say ranges in nearby jurisdictions do not keep similar records. Yeah, half-hour member, something like that. It should have been easy enough for the city to check, and court engaged in, I think it was a little bit more than that. I think it was more like an hour that I gave notice. Any serious form of scrutiny would have been questioned in absence, but no substantiation was provided or demanded. In sum, the city's travel restrictions were in very right recognized in Heller. History provides no support for restriction of this type. The city's public safety arguments were weak on their face, were not substantiated in any way, and were accepted with no serious probing. And once we grant review, the city's public safety concerns evaporated. Very nice. We're told this mode of review in this case has been representative of the way Heller's been treated, which it pretty much is. If that's true, there's cause for concern. The case is not moot, the city violated the rights, and we should so hold. I reverse the judgment and demand for appropriate relief. I therefore respectfully dissent. Okay, cool. Yeah, I think their frustration is a little bit misplaced. Yeah, ask Crowder about YouTube notifications. No joke, right? Yeah, no joke. Yeah, that man cannot get a break. He doesn't violate any terms of service, and they won't let him be a partner. Someone's name who I assume is in Russian, and as a result, I will not attempt to pronounce, because, how could I possibly, says, what do you think about a separate notification app? That'd be good. So, there are definitely 4 votes that are very frustrated. There are definitely 4 votes that are looking to make this a case. Is the dissent right about the mootness? I mean, you could make a case for it. And they did. But I think it's a little bit misplaced. I think it's a little bit misplaced. I'm not saying that's not right. It's a little misplaced for my taste. They're just frustrated, and they should be. And the way they should fix that frustration is by granting 5 other cases and dealing with that. Their frustration is that they don't grant enough of these cases, and then every time they do, they disappear because they grant them so infrequently. They need to grant a whole bunch. They can't all disappear, and then they'll be in a better position. So I think their frustration is a little misplaced. So if I were on the Supreme Court, which way would I go? I don't know. Honest to God, no. I'd be looking to see if there's some other cases I could grant cert on. I can tell you that for damn sure, because I definitely want to hear some other cases. And if I hadn't put all my eggs in this basket, I'd be looking for other cases. You know, so that's what I would probably be doing. Is I'd be looking for something else to grant cert on. So I'd be probably with the saying it's moot. Because I want to do just something somewhere else. But then I'd actually do something somewhere else. That's how I deal with this. There's enough for me to keep it alive. It's technically enough for me to keep it alive, but I'd rather deal with it somewhere else. Just a personal opinion. Just a personal opinion. Yeah, it might be a technicality for an excuse too. It might be that too, that they're using the technicality because they don't really want the cases. So Roberts doesn't really want these cases. So he's looking for any reason to get rid of it. I didn't quite get that sense from Kavanaugh, but it could be. But I think it might be a fair characterization of Roberts. $5 from El Rojo Grand. The Great Red One. Thank you for your contribution. It is appreciated. All right, so for those of you who are here and like this, I hope you liked this read. I thought it was very informative, very thorough, and we'll only hope to see if we can get more cases. So we are going to try to do something that is a Twitch thing, which is we're going to try to do a raid of. Did I hear the case of Hopewell with the gun range? I did not. We're going to try to do a raid of Viva's channel. So as soon as this stream is done, we're all going to go to Viva's channel, and we're all going to type the same thing. And because I'm leading the raid, I have to be the one who comes up with a really clever thing that, Viva will not understand what the hell is going on. So let's go with, say this. Go to Viva's stream. Hello from your unlaws. Hello from your unlaws isn't bad. What? Yeah, come me. Yeah, you don't know who Aviva is? He's another YouTube guy. I'll give you a link to his thing. Okay, here's a link to his stream. Okay, this is a link to his stream, and we're gonna come up with something to say him. So yeah, he's another lawyer, and we're going to come up with something to say. Let's go with hello from your in-laws. All right, we're gonna go with Evil Tribble. So go to that URL and go to that live chat and type in this. And we're going to do this and see how that goes. I'll see you over there in a bit. For all you guys, hope to see you over there. See you soon. Love you. Bye. Unlaws. We're uncivil law. Unlaws.
Pigeonholing, categorizing, reducing a complex individual